Hello, welcome, good evening. I'm Shirley Jefferson. I'm the Associate Dean for Student Affairs and Diversity and Associate Professor here at Vermont Law School. Welcome to Vermont's Law School Embedded in the Racism Law Series. Tonight, our presentation is Racism and Legal Education. I also bring you greetings and regrets from our interim dean and president, Beth McCormick. She is unable to join us here today, but she sent her regards and she thanks all of us for putting on such a great panel, and she thanks us for our commitment to continue to fight injustice. These panels we started back after the tragic death of George Floyd and Breonna Taylor and others. Our community was starving, or should I say thirsting, for knowledge on how can we make our society more just for all of us and fair. And so we started these embedment panels. We put on about 12 or 13 of them, going from racial discrimination, employment discrimination, quality immunity, micro and unconscious bias in the classroom, structural racism, and American culture. We touched on a broad topic of areas. At the same time, our students became very engaged. They looked at the way that we were doing things here at this law school. They started working on an anti-racism statement, but it ended up not just being a statement, it was more like a resolution. So we started working with them, and faculty became very engaged. They end up working on the anti-racism statements, almost like all of the other statements that say we're going to fight, and we're going to continue to fight injustice. We're going to bring DEI and critical race theories into our curriculum. All of those things. But we also had a diversity plan and strategic plan. The students work with us on that. A lot of our goals and initiatives in that plan, which is on our website, it comes from our students working on that anti-racism statement. Now, Aaron, when you and I started off 20 some years ago, diversity, it was just diversity, it was race and ethnicity. But now it has branched off into a lot of other attributes: socioeconomics, disability, gender, age, geography. But not only that, you brought in equity and inclusion. And our students said that you're doing kind of great on diversity as far as students, but diversity as far as faculty and staff, you need some help. And also including things here on this campus. So we had 6 goals and initiatives that we were working on. 2 of those goals talked about diversifying the faculty, staff, the board of trustees. One of them talked about getting money. With diversity, you got to have finance and human resources to support these goals. And then it also said, you all have to increase the ability of diverse students to succeed in law school and to feel welcome, respected, and supported here in this community. Also, to increase the ability of the administration, faculty, and staff to address sensitive diversity issues in a respectful way. And so the diversity committee, we started working, and we will now next week, we'll start looking at these goals and initiatives. We're going to prioritize them. We're going to see which ones are realistic, which ones are not. We'll look at where we're falling short, and then we will look to see what steps need to be taken to achieve those goals. Now, our students sent us a message last week. They was like, y'all, come on, y'all moving kind of slow. They had asked in the plan about a DEI, Dean just dealing with that, because my position, you dealing with both of them. And we were already working on it. So Monday, we advertised for our diversity, equity, and inclusion dean. They wanted a multicultural center. They started walking around campus. Lorraine Atwood and some other professors looking at a space. They said, just want a space where they can go there, but also have culture stuff, hold events, just want to kind of have a little spot. Also about us being more accountable to the students, and also about faculty incorporating diversity and equity in their classroom. And that's where Dean Lewis is going to come in and talk a little bit about that. But I want to say that we're working hard. We have a long way to go. We're committed to our diversity plan. We're committed to having the next generation of leaders, not only that they know the Black letter law, but they know where they can make changes in institutional and the systemic racism that our society has been moving stronger instead of lesser toward. And I grew up in Selma, Alabama. I was part of the civil rights movement with Dr. King. I dedicated my life at an early age to fight injustice, and I have, and I've done the best I can, and I will continue to fight and continue to work to make this country stand up to what its Constitution said. It was going to treat everybody fair and right. And with that ending, I'd like to turn it over to Dean Lewis. Thank you all for being here tonight.
Well, thank you, Dean Jefferson. Let me just say that it is an honor to work with you. I am just a door or so away from Dean Jefferson, and the life and enthusiasm that she brings to our community is just beyond notice. So good evening. Thank you so much for allowing me or inviting me to offer remarks as part of today's Embedded Racism in the Law panel. I think when thinking about legal education, we have so far to go, particularly with the area that we study. So the study of law, while fascinating, it's what we've all come to love, it's very predictable. First-year students across the legal academy study the same thing. They take the same courses. They take con law, they take property, torts, civil procedure, even legal research and writing. So those doctrinal courses require students to learn the rules of law by reading cases that were decided a century or more ago in some cases. Students also take skills classes such as legal research and writing. Professor Noah Messing observes that law schools teach students to write like lawyers by asking them to read old cases by dead judges who learned to write by copying older, deader judges. And I think we can agree that the majority of these judges were white males. So we love law because law is a vehicle for change. Achieving racial and social justice motivates students to attend law school. Thankfully, today's law students are first generation. They come from historically Black colleges and universities. They identify as binary or trans, and they represent all genders, races, and socioeconomic backgrounds. How will these students be able to engage with the law school curriculum that has been around for centuries? How can law schools integrate legal doctrine and diversity? Clearly, the work lies with the faculty. At the annual VLS faculty retreat last fall, Dean Jefferson and I provided a copy of Integrating Doctrine and Diversity, Inclusion and Equity in the Law School Classroom. We invited two of the editors to meet with the faculty during the retreat. Librarian Nicole Dysleski and Professor Suzanne Harrington-Steppen described how faculty at Roger Williams University School of Law gathered once a week to talk about their classroom experiences. What have they done to ensure that students were included in the discussion and shared perspectives? How do they introduce current events into the discussion? What did faculty incorporate based on the tools provided in the text? Modeling the Roger Williams approach, VLS faculty began a similar discussion group. Then, again at the end of the fall semester, Nicole and Susie returned, unfortunately virtually again, to check in with faculty about what had been working well in the classroom and where faculty wanted to improve. We plan to invite our colleagues to return twice more, once at the end of the spring semester, and then again at next fall's faculty retreat. We want to have a full year curriculum for faculty and provide a space for them to learn and grow. In addition to the classroom environment, law schools must also address the overall curriculum. Faculty must embrace the notion that issues of racial justice are not reserved for Dean Jefferson's Race in the Law course. Issues of sexual and gender identity are not reserved for Professor Johnson's Sexual Orientation in the Law class. To that end, next week, the Curriculum Committee will send a survey to faculty as directed by the Diversity Report and Plan that Dean J just mentioned. The survey directs the faculty to regularly evaluate classroom teaching and culture to understand and eliminate racial and cultural bias in the classroom, and as well as with their course materials. Faculty will be asked to complete the survey for courses taught during the last 3 years. The instructions direct responses from faculty to be candid and accurate. In conclusion, the overall legal academy can be slow to change. However, even the American Bar Association section on legal education, one of our accrediting bodies, adopted new standards just today or yesterday, I believe, requiring accredited law schools to provide education to law students on bias, cross-cultural competency, and racism. As Dean J said, Vermont Law School has work to do, and we are eager to demonstrate our commitment to creating an inclusive and equitable environment for learning for our increasingly diverse community. I thank you so much again for the opportunity to participate in the panel. And now it is my pleasure to turn it over to Kaci Stewart, who is our current president of BALSA. Thank you.
Thank you, Dean Lewis. Thank you to Dean Jefferson as well as Heather Francis for the invitation. I proudly serve as the president of the Black Law Student Association. I have the honor and the privilege of serving every single Black law student on this campus. Our theme this year was, how do we go from information to implementation and activation? And so how do we go from having conversations such as tonight about racism in law school and to actually implementing that into our own lives and then teaching other people about racism in law school? And so this Saturday, February 19th from 9 a.m. to 1 a.m., BALSA will be hosting our annual Race in the Law Symposium. The uncomfortable topic that we'll be addressing is legal preparedness and employment. And so for Black law students, we know that a lot of our issues stem way before we ever even arrive on the campuses of law school. And so how do we prepare Black students long before they get to law school? Another thing that we'll be doing, instead of just having the roundtable discussion, is we'll be hosting the symposium over Zoom so that we can allow for breakout rooms. We have assigned students to capture the information that the attorneys and clinical professions are going to be sharing with us, because we plan on sharing those notes with our families and friends who are professors, who are pastors and preachers and academic professionals, how we can go from having the roundtable discussion to sharing that information to actually getting it into the classroom. And so those 3 panels will consist of diversity, equity, and inclusion. We know that's a hot topic, but we want to start talking about how do we increase those numbers, as we discussed a little bit earlier here today. Our second panel is going to talk about mentorship. We know that mentorship is important. However, how do we continue to keep our mentees engaged throughout the entire process? And then the very last panel is going to be mental health. We know that mental health is definitely another hot topic, but how do we care about the whole person, the mind, the body, the soul, and the spirit? And so we invite you out. I'll make sure that I include the link into the chat. It's going to be a very intimate conversation, and we look forward to as many people that would like to lend their expertise in all 3 of those areas. And so Dean Jefferson, Heather, and Dean Lewis, thank you so much for inviting me and allowing everyone to just extend that invitation to everybody. I look forward to seeing you guys on Saturday. Thank you.
Good evening, everyone. My name is Heather Francis, and I am a 3L Joint JD Mafalp student at Vermont Law School, and I currently serve as the Senior Notes Editor on Vermont Law Review. Tonight, I will be your moderator. First, I want to say thank you to Dean Jefferson and Dean Lewis for your opening remarks. I know how much you do for this school because I got to work closely with you all last year when I served as SBA president, and all that you are doing for this school I know inspires me and inspires our student body. I also just want to say thank you to Kaci for joining us. I hope that everyone listening in can make it to the Race and the Law Symposium this Saturday. I know the organization has worked extremely hard to make this symposium happen. All right, I am eager to introduce you to our panelists tonight. Each panelist will give a presentation related to their expertise focusing on racism in legal education. After they give their presentations, we will open it up to questions from our viewers. We have three amazing panelists tonight. They are Erin Taylor, who is the Executive Director for the AccessLex Center for Legal Education Excellence, Professor Roberts, who is an adjunct clinical law professor and supervising attorney at Howard University School of Law's Fair Housing Clinic. And finally, Professor Atkins, who is an assistant professor of law at Elon University School of Law, located in Greensboro, North Carolina. Okay, I'm going to introduce Erin Taylor, who will be our first panelist. Erin Taylor provides leadership and oversight for the AccessLex Center for Legal Education Excellence. He joined AccessLex Institute in June 2017 from St. Louis University, where he served as a professor of law. He also served as director of the Law School Survey of Student Engagement, a national study that measures the effects of legal education on students. Dr. Taylor's scholarly articles have appeared in journals published by American University, Howard University, Stanford University, University of Notre Dame, and University of New Mexico. His commentaries have appeared in numerous publications, including the Chronicle of Higher Education and the National Jurist. He is also a frequent media commentator on education and diversity issues. Dr. Taylor received a Bachelor of Arts in Political Science from North Carolina A&T State University, a Juris Doctor from Howard University, and a doctorate in Higher Education Leadership and Policy from Vanderbilt University. He is also an alumnus of the Harvard University Administrative Fellowship Program. I'll turn it over to you.
All right. Thank you, Heather, for that introduction. I guess I'm off mute. Yeah, I am. Fortunately, I usually forget to unmute myself. But thank you, Heather, for that introduction. Thank you for the invitation to take part in this important series. And I'll join Dean Lewis and others and acknowledge my friend, Dean Shirley Jefferson. I met Dean Jefferson about 20 years ago or so now. Time really flies, I tell you. When I was just starting my career in law admission, and she has always been an amazing source of guidance and inspiration and friendship. So thank you, Dean Jefferson, for all you've done for me and also all you do for Vermont law students and the legal profession. So the theme of this series of discussions is embedded racism in the law. And so the focus of my brief talk will be reflections on how we as legal educators can best train our students for the complicated world that they will encounter as professionals. If the last few years have taught us anything, it is that the rule of law is not a given. It requires constant nurturing, support, and accountability. And these are fundamental lawyering functions. Therefore, the quality, relevancy, and responsiveness of legal education to contemporary societal challenges are critical to determining the future of our democracy. I've long said that I received some of my best education in the law as a child. And these lessons were informal, with most not really intended to be lessons at all. They really just came from observing the conversations that the adults around me were having. And the thing I remember most vividly about many of these conversations was the extent to which the specific topic or issue that was being discussed was nested within a larger framework. And that framework was often referred to as the system. So for example, if a discussion was about a neighbor who had gone to court and got what appeared to be an unfair criminal sanction or a fine or something like that that was unfair, the conversation would invariably point to the unfairness of the system. Or if the conversation was about how the community in which I grew up and where my neighbors were and where some of my family, my friends were, why that community had less access to resources and less access to wealth than communities on the other side of town, the conversation would again similarly point to the system as fostering this outcome. So the system seemed opaque to me at that time. I couldn't quite wrap my mind around what it was, but I would eventually conceive it as this invisible, irresistible force that worked to the favor of some at the expense of others. But as I lived more and learned more, was exposed to more, I realized that the system is more unnoticed than invisible. It blends into the scenery because it is the scenery. Literally, when you're talking about blighted communities sitting a few blocks away from million-dollar homes, the system encompasses the economic, social, and cultural facets of one's life. For many, the system dictates life's chances. And as my early exposures demonstrated, many people disfavored within the system are acutely aware that their station in life is much more the result of this intentional design than of any kind of natural order or some objective conception of deservingness. And this awareness can be a source of deep frustration when combined with a lack of power to force near-term change. Most of my early legal educators were not legally trained. Some of them did not have much education at all, or at least formal education. And yet my exposures to their depth of knowledge and awareness and wisdom inform much about how I have taught my law students. To me, it seems impossible to teach law effectively without embedding the law within the system that gives it force. I learned this early in my teaching career. So during my first semester, I was teaching a course, an education law course, which was essentially con law through the frame of the reams of education cases that have been decided by the Supreme Court. So we were covering the section on school desegregation, and this is a string of cases, Supreme Court cases spanning more than a century, from Plessy Ferguson in 1896 to parents involved in 2007. And so my approach to the course was to focus squarely on the cases as presented in the four corners of the case book. And in my syllabus advised, and I'm going to quote this, class discussions will rely almost exclusively on case law and related hypotheticals, right? I wanted students to leave the course with a strong grasp of the law, a strong grasp of the precedent, and how it had evolved over the decades. But education policymaking isn't neat and tidy, right? Virtually everybody has a stake in the function of schools, and decisions regarding resource allocations are commonly seen as zero sum, and they sometimes are. And moreover, schools are like these classic open systems that are often at the center of societal struggles, whether they're economic, political, cultural, or all of the above and more. We're seeing battles about masks and vaccines and all of that kind of stuff playing out in schools right now. And so when intractable contention arises, the legal process is invoked to set or iterate the rules of engagement. So I saw the cases that we covered as the Supreme Court basically calling proverbial balls and strikes, fair and unfair, that kind of thing. The problem, however, was in the way that I sought to separate this judicial refereeing from the context in which it was being done. And this incongruence played out several times during the semester, but one incident stands out. So we were discussing Swan v. Charlotte-Mecklenburg Board of Education. And this is a Supreme Court case where the court stipulates that busing, so busing kids from one side of town to another side of town, was an allowable means of integrating racially segregated schools. One of my students raised her hand And she commented that busing and presumably the influx of Black children into formerly all-white schools led to an overall decline in quality of life in East St. Louis, where her family was from. So a bit of background about East St. Louis, if you don't already know. East St. Louis is a suburban city in Illinois, and it's just over the Mississippi River from St. Louis, Missouri. East St. Louis has a very fraught and violent racial and racist history. And like many suburban towns, it was once majority white and wealthy, and now it's majority low income and essentially all Black. My student credited her grandmother for this perspective about the effects of busing. And the perspective embraced a major theme of anti-busing rhetoric and this idea that busing introduced negative elements to these previously serene communities was unavoidably tinged with racial animus. But I didn't want the discussion to stray too much from the four corners of the opinion, so I swiftly acknowledged the statement and moved on. After the semester ended, I was reviewing the course evaluations, and another student commented that I should have challenged fallacious assertions that were made in class and forced the people who uttered it to defend their statements. In that moment, and actually the student also said that I legitimized these statements by allowing them to go unchallenged. And so in that moment, I realized that the student was right in their evaluation, and that my mind immediately went to that busing comment. So the need to foster an inclusive learning environment was a compelling reason for me to have personally addressed that comment as the professor. But it wasn't the only reason. Post-Swan, the US Supreme Court made it increasingly easier for school districts to demonstrate that the vestiges of their unconstitutional segregation had been dismantled, and therefore they should no longer be subject to federal supervision. We discussed this shift in class because it was important, but what we did not discuss was how other factors, including politics, had a direct effect on the evolution of the court's approach. For example, Richard Nixon, who was strongly anti-busing, nominated 4 justices to the Supreme Court. And it tilted the court towards a more hostile view, not only to busing, but to federal intervention regarding any issue that could be described as a so-called local issue. This context is relevant, not only to the student's assertion about busing, but also to the 4 corners of the court's opinion. My initial approach of focusing squarely on the text yielded many missed opportunities for student learning. I had in effect positioned the cases as pure expressions of objective justice, like holy commandments or something. But some of my students knew better. They knew that context mattered. They knew that the judicial opinions were influenced by the subjectivities and the biases of the justices who wrote them. They knew that the legal process is part of a system intentionally designed to favor some over others. For some students, this awareness came from firsthand experience that I diminished as if I didn't have similar experiences myself. And the result was the type of academic marginalization that was expressed in the evaluations of the course. This experience shifted my teaching philosophy. My focus became training students to not only learn and apply legal rules and case precedent, but to also interrogate the system. After all, the best lawyers not only know what the law is, but they also understand how systemic factors impact legal issues, legal strategy, legal remedies, and also their clients' lives. This approach fosters an inclusive learning environment because it provides structure for varying perspectives and lived experiences to be acknowledged, considered, and interrogated. It also provides a structure for leveraging fallacious assertions as teaching tools. In many ways, my courses look very different from traditional law courses and very different from the courses I was teaching at first. We would start each module with 1 to 2 what we call big questions. And these questions would be framed to give them real world relevance. So for instance, a big question for the school desegregation model was, and this is a quote, more than 60 years after the Supreme Court deemed segregated schools unconstitutional, most school children still attend racially isolated schools. How is this possible? The framing hit home for most of my students because most of my students attended racially isolated schools themselves, as did I. I wanted my students to not only know what the law says, I wanted them to know the factors, stated and unstated, historical and contemporary, that underlie what it says. And I wanted them to know the impact that the law has on real people, including themselves. In the context of the education law course, they should know how the law allows for racially isolated schools, even though we banned segregated schools 60 years ago, I guess close to 70 now. But the students should also know how racist housing policy and economic policy and a whole lot of other things have brought about this result in the first place. Fundamentally, I wanted to equip and empower my students to think like lawyers of the highest order. Overall, I think legal education has a lot of work to do in educating law students to think systemically. I recently did a review of learning outcomes for the roughly 200 or so ABA approved law schools. About 60% of them had at least one learning outcome pertaining to fostering diverse, equitable, and inclusive learning environments. About half of them had at least one learning outcome pertaining to teaching students how the law interacts with other regulatory systems. And only about 15%, that's 15% of them, had at least one learning outcome pertaining to teaching students about how the law impacts people and not just their clients who are paying them. All of these proportions are paltry, in my opinion, particularly that last one. And if we can't trust that the lawyers we train will have an awareness of the racism embedded within the system, our prospects for doing much about the resulting inequities seem slim to me. So I'll end there, and I look forward to learning from Professor Roberts and Atkins, as well as answering any questions that viewers may have for me. So thank you.
Thank you so much. And I look forward to the Q&A portion where we get to hear more from you. So next, I will turn it over to Professor Roberts. Professor Roberts, following graduating law school at Catholic University of America, Columbus School of Law, worked in various legal settings, including clerking for 4 judges on the DC Superior Court and litigating family and public benefits cases on behalf of indigenous DC residents at Neighborhood Legal Services Program. In 2017, Professor Roberts successfully graduated from the DC Bar's John Payton Leadership Academy and also ventured into academia, where she began the journey by working at Rising for Justice, formerly DC Law Students in Court, as a supervising attorney in the criminal and later the Housing Advocacy and Litigation Clinic. In addition to her duties as a supervising attorney, Professor Roberts also was the co-director of the Civil Protection Order Project. Currently, she is an adjunct clinical law professor and supervising attorney at Howard University School of Law's Fair Housing Clinic. Her legal scholarship centers on the access to justice, clinical pedagogy, and implicit biases and client advocacy. Take it away.
Thank you again for the invitation, Heather and Aaron, Tiffany, Dean Jefferson. I am so excited to present. I think this is a very important topic and very timely topic. I'm going to talk about how I view this topic, racism in legal education, from a clinician's perspective. As Heather has stated, I was a practitioner before I became a clinician, and so I kind of look at this issue with that lens. I practiced law in the District of Columbia for over 15 years, 7 of which was at Neighborhood Legal Services Program. And for those who don't know, this program is over 50 years old. It's one of those programs that kind of came out with Johnson's War on Poverty. It was one of the first neighborhood offices that was open in DC. I rose to the ranks of in that program. I started as a temporary staff attorney, then staff attorney, then managing attorney, interim managing attorney, and then managing attorney. Within that time frame, I had an opportunity to practice family law and public benefits law. My focus in family law was representing fathers, usually non-custodial fathers, fathers who don't necessarily have custody of their children, in domestic violence cases, child custody and child support cases. I felt that these are the individuals who really weren't represented or didn't have lots of avenues for representation. So I kind of focused my efforts and my management of my staff attorneys towards that end. He also had opportunity to interact with Ward 7, which was my office was located in Polk Street. Ward 7 is a vibrant historical ward in the District of Columbia. Majority of the individuals who were there or who are African American. Also, the ward itself has a high number of what I would call returning citizens coming back into the community after serving a term of incarceration. And they also have an aging population as well. Within that, I did a lot of Know Your Rights presentations. This basic information about what rights are for housing, for instance, or rights with regards to child custody or how to file a divorce, things like that in Ward 7 and 8. In addition to those things, I also did presentations, not only Know Your Rights presentations, but also talk about court systems and how court works, and try to provide my clients with a sense of power with regards to how the systems work, and also try to tackle issues that we think that doesn't work quite well for clients and see what systemic change we could make at that time. Well, now I work at the historic Howard University School of Law. As you know, Howard is a well-known HBCU law school. It was established in 1869. Its alumni are voluminous, one of which is Thurgood Marshall, and of course the architect himself, Charles Hamilton Houston. We are at Howard, we think about how race interplays with all areas of law. Is this within our DNA? This school, we are in the forefront of legal advocacy, civil rights advocacy, and the like. So this is an environment that I thought that really, takes in consideration thoughts and really thinks about how to integrate race, law, and poverty in all areas of practice, all areas of study, not only the traditional areas, but all areas. Now, let me tell you a little bit about the Fair Housing Clinic. Again, this is my baby, my clinic. Myself and another supervising attorney, we manage the clinic. And we study both aspects of public and private housing. Under the guise of the Fair Housing Act, the DC Human Rights Act, and other DC laws with regards to housing conditions and eviction defense. We do that through direct representation. We do it also through legislation drafting or commenting on legislation, both federal as well as local. And we also do a lot of testimony before DC Council with regards to issues or to legislation that we think is a good idea or opposition to legislation as well. And the thing that I love about this clinic is we actually get on the boots on the street. We actually, even with COVID, we actually do a lot of community outreach and work with the community that we serve. The majority of the individuals that we serve are residents of Ward 7 and 8. So I'm going to tell you a little bit about who our clients are. The District of Columbia has the highest poverty rate in the country. They are. Over 60% of tenants who are being evicted take place east of the river, east of the Anacostia River, which are the Ward 7 and 8. They have the highest rate of poverty. They also have the highest rates of people of color within those wards. 42% of children live in families with no parent, where no parent has a full-time or job or year-round employment. And also 1 in 7 DC residents, especially in Ward 7 and 8, are food insecure, and which that means is that they have no reliable access to affordable and nutritious food. For instance, there's only one grocery store in Ward 8, and Ward 8 is a huge ward, but it's only one store, one whole food store in the whole entire ward. And so you can imagine how difficult it is to get fresh food, to get affordable food there is for residents in the District of Columbia. in that order in particular. My clients also, they are experience chronic unemployment. Some of them don't have a high school diploma. The households are usually held by single parent mothers or grandparents or nuclear family type living arrangements. And also they had some kind of a contact with the judicial system and law enforcement, and usually that contact was not positive. Okay. My students, I have 10 students a year. We have a year-long clinic, and we are allowed to, in that clinic, we within Howard's tradition, we really talk about race and poverty and how we as practitioners and as representatives of our client, or advocates for our client, rather, how we interact with our client is important, right? Going back when I started working at this position, all the civil unrest was really unraveling, and I was trying to figure out how can I, the questions like, how can I address these issues that I know that we need to address? How can I do them in a safe manner? How can I talk about them in a safe manner? And I came up with talking about, our clients in general and who they are, and identify who they are. And I also talk a lot about implicit biases and then what they are. And I said to everyone, there's no one's a bad person. We all have biases. Our brains are like information, have like computer programs, and they only have so much information, room for so much information. And so how we do it in our brains, we categorize things in order to, for lack of a better word, to preserve space, so to speak. Well, that allows us, unfortunately, to have implicit biases, right? And I have them to define and think about their own biases through doing a spent exercise, or doing one of the biases testing, just to see what they are, and also having a frank conversation in a safe place with guidelines to talk about these issues within the group. And all opinions are important, and all comments are listened to. I also really focuses on their own biases and how those biases can bleed into your a student's ability to actually to be a good advocate for the client. If a person if you think that the client is lying or is some reason not responding to you, you may think about not prioritizing that client. Client's case may not be first, it may be last on the bottom of the pile, right? It may influence your how you evaluate your evidence, whether or not your client's telling the truth or not, whether or not your client, if you believe your client is instead of your client paying rent for the week, for the month, the client bought an Xbox, right? And so that may affect the way you see your client and the way you advocate on behalf of your client. And it also has a potential for you to, for our advocate, student advocate, to pursue what the student advocate thinks is the best thing to do over what the client's interests and goals are, right? And that's a big no-no, right? We practice client-centered lawyering, and the client is the center of our representation, and we just hold the mic up to them in a sense that we amplify their voices. We don't replace the client's voices for ours. We just amplify them so they can speak in themselves. Also, I think interpreting client behavior or the like if you had a client who didn't return phone calls, pressing pause on that, suspending a student's biases, and to really think about what other reasons could they be for the lack of communication, and just slow their biases, because it could, quite frankly, be another reason for the miscommunication. For instance, it could be that the client only has limited amount of minutes, and he or she ran out those minutes by the time that you called her, if she can't return your phone call until the next month when she has more minutes. So there's always an explanation, and a lot of this exercise is just to try to get them to stop and to think, park their own biases, and keep an open mind. Also, the assumptions, I think that a lot of students had assumptions about our clients, especially coming from Ward 7 or 8, the education level, then they're not intelligent because they don't have a degree. Degrees don't necessarily equate intelligence, right? And so we have to suspend that and not assume that our clients, because where they live and who they are, and the issue they are having to confront, that they have some kind of educational level. Same thing with regards to someone has mental capabilities, mental difficulties. Just because someone has mental difficulties, that necessarily mean that he or she cannot make decisions on her own behalf, right? And so that's something that I have to suspend students from really concentrating on the same way that I would do so if I was back in LSP when I was having staff to do that as well. Also, it's important to have cultural competency, and we have a long discussion about, what exactly that is, and then why is that important to anything, right? Because I think that being competent and empathizing what a client, being culturally competent and sympathizing rather with your client allows you to, again, to be able to understand your client's behaviors and choices. The choices are not necessarily the ones that you would make, but it will suspend your own opinion, your own biases, and it will allow you to understand what your client's goals are. And I think that, being competent, like for instance, I was raised to call individuals who are older than me by ma'am or sir, right? Some older African-American clients, that it's really important for you to address them correctly, right? And so if I know that, then the relationship we can start our client relationship on a better foot, because I understand that, and it minimizes miscommunication between myself and my client. And also to put my client at ease. If my client my client's pronouns are not he or she, is they, then I need to refer to them as they and not as he, right? And so I want to put my client at ease as I'm, representing them, and that in turn helps really to bolster, their trust in me, and it also makes my advocacy on behalf of the client more effective. And that's about it. Again, thank you for allowing me to speak. Given my point of view from a practitioner in a coalition, I am willing to take any questions at the end of discussion, and thank you.
Thank you so much, Professor Roberts. It was really great hearing about your work in the clinic. All right, finally, I am happy to introduce Professor Atkins. A 2011 graduate of Elon University School of Law, Professor Atkins is a first-generation college graduate and lawyer, proud Zillennial, and an assistant professor of law at Elon University School of Law. She teaches first-year legal writing, upper-level writing courses, and race law courses. Prior to teaching, Professor Atkins was a public interest attorney with Legal Aid of North Carolina. Her first article, For the Culture, Generation Z and the Future of Legal Education, examined this within the context of law school classrooms, and her current work, These Brutal Indignities, Making the Case for Crimes Against Humanity in Black America, looks at the structure of domestic and international law, recognizing them as barriers to the full protection of Black human rights. Prior to joining the permanent faculty at Elon Law, Tiffany completed a 2-year legal method and communication fellowship at Elon in 2018 and was a visiting assistant professor at Wake Forest Law School until 2019. Take it away.
Well, good afternoon. Thank you so much. Or good evening. It's 6:50. Good evening. Thank you so much for the invitation and for inviting me to participate in such an important conversation about what I think the topic of the talk is embedded racism in the law series. What I am going to talk about for the next few minutes is how we disrupt the racism that I experienced in law school, that many of you have likely experienced in law school? How do we disrupt that? So honored to be here, honored to share space with my fellow panelists, Professor Roberts and Dr. Taylor. Really, this panel, this discussion that I'm going to share is really centered around how to create classrooms like that Dr. Taylor mentioned, where we're teaching students how to analyze cases in a really intentional, powerful way, or clinical classes where we connect what students must know, the law that we tell them they must know, the things they have to learn for the bar exam and to be practitioners, how to connect that with what they want to know, how to connect that with the causes and things that are important to them. So I'll be talking about how to disrupt and how to, I guess, unembed racism in law school by focusing on why we need to do the work and for whom. This presentation is based on a paper that I wrote called For the Culture, Generation Z and the Future of Legal Education. I'll drop a link to that in the chat in just a little bit if you'd like to read it. So the paper begins first, or the presentation will begin first with an overview of Gen Zers. I have a Gen Zer at home. Many of my students in class are Gen Zers. There may be Gen Zers here. This passionate, powerful, non-traditional cohort of students. We're going to talk about them. And then we'll talk about the culture of legal education, which really is, in a lot of ways, it clashes with the culture of Gen Z students, which really does activate their vocalism, which activates their advocacy. And finally, we'll talk about what we can do institutionally and in the classroom to disrupt racism, bias, and stereotype threat, and instead, in their place, embed inclusion, representation, equity, and belonging. So I'm a professor, so I have a little bit of work for you. So when you think of Gen Zers, what word or words come to mind for you? If you could type that in the chat. When you hear Gen Z, I don't know if this person that I have here is a Gen Zer, but when you hear Gen Z, what are some words that come to mind for you? So if you'll put that in the chat, young, okay, I see young, they are. So the age range for Gen Zers, they were born between 1997 and 2012, right? So they're the youngest sort of cohort, the newest cohort to come of age. The oldest Gen Zers are about 25, the youngest are around 10 years old. So there's a range there. They're diverse, right? Nearly 46 to 48% of Gen Zers consider themselves non-white. So studies are saying that they will be the last generation with a white majority. They will, in their own sort of composition, challenge how we think about majority, minority because of how diverse they are. Tech natives, that's another good one. They're connected, and that goes to the point of Dr. Taylor's comment. They're connected. These students have never known a time before Facebook, before the internet, compared to how I was raised when TV used to go off the air and the little flag would wave and you had to collect calls. They know nothing about that. They are connected. And in response, they expect information at their fingertips. They expect instantaneous information. They're passionate. We saw their passion in action in the spring of 2020 after the killings of Breonna Taylor, George Floyd, and many others. We saw them taking to the streets. Many movements were led by Gen Zers. So they are passionate about the causes that are important to them. They are motivated by making a difference for others and standing up for what they believe in. They're non-traditional. This non-traditional aspect applies to gender norms. They don't conform. They don't want to be placed in a box. They're non-conformist and non-traditional, and they expect institutions and organizations they interact with to respect their sort of non-binary nature. These last two, isolated and insecure. And so on the isolated piece, this is connected to the connection. They're so used to connecting on their phones that they aren't used to the face-to-face interactions. They don't go to parties like we used to go to parties or school dances. So they're used to connecting through a screen, but not really together. And this has led to what scientists and psychologists are saying is a mental health crisis, which has been compounded by COVID. So I want you to keep all these characteristics in mind as we start to talk more about law school culture. Let's talk about them being vocal. What I want to be clear about is that Gen Zers are not all the same. I'm not going to overgeneralize them to say, oh, they're all liberals, they're all motivated by these social or liberal social causes. They are individuals who believe in causes that are important to them. In my research, I came across this group. This is the Conservative Hype House on TikTok. There's also a Republican Hype House on TikTok, 2 million followers strong. At this point, they might have even gained more. And their whole platform is designed around disabusing us of the notion that all Gen Zers or young people are liberal. They are ultra conservative, very vocal Trump supporters, and they are using their voices to make a difference for the causes that matter to them. As you'll see here, the causes may change, but the message is the same. And I apologize for the profanity. In my paper, the topic headings, the headings of the paper were taken from protest signs. This is the energy, regardless of the cause, they believe that the advocacy and the ability to change the problem is up to them. And we see this in our classrooms. Dean Jefferson mentioned this at the beginning of the talk, that students applied pressure. They pushed the institution. They protested. If your students are like my students, they wrote letters, they organized protests, they put pressure on our administration, the main campus administration. And at any given point in our classrooms, all of these divergent views are present. Let's look at some market data about Gen Z. So in addition to these divergent viewpoints in the classroom, in the institution, there's lots of divergence of opinion. So this chart shows us the difference in viewpoints on the topic of Black Lives Matter. So 81% of Gen Zers support the Black Lives Matter movement. Compare this to the bottom row, 56%. Only 56% of boomers support Black Lives Matter. Well, who's running our law schools? What's the generational cohort of the deans? Often, sometimes, and most times it's boomers, because they've been around a long time. They have lots of knowledge, lots of education, lots of experience. But when you put these groups into a classroom or into an institution, when they have very different views about these matters, there is the potential for conflict. If students are pushing for movement or for support, but the leadership doesn't agree, this can often be or cause conflict. Gen Zers care deeply about how brands respond to Black Lives Matter. So assuming these same trends can apply to law school, here you'll see that 66% of Gen Zers surveys say they will decide where and how to spend their money based on a company's response to Black Lives Matter. So think about how these expectations play into our classrooms. It's unacceptable for them for a professor to begin a class and not acknowledge the Black man that was killed or tackled by police the day before yesterday. It's unacceptable for us to begin a class and not acknowledge atrocities happening on the news and in our communities. They expect their brands, their organizations to respond to the social causes that are important to them. But they don't just want lip service, they value action over just statements. So here, 82% of Gen Zers say they're looking for action and not lip service. And so if your students are like ours, they're continuing, and it sounds like they're continuing to apply pressure as you admit more and more Gen Zers. They're going to continue to push the institutions because they expect more. The way they were raised was in a very diverse culture. They expect this diversity in the places they live, work, and learn, and they're not afraid to activate to achieve that. So given this, what are the opportunities for law schools, for individual faculty and leaders? Considering not only Gen Zers' social demographics or their needs and expectations around equity and inclusion and diversity, but sort of the goal of legal education as a whole, making these adjustments and recalibrations, not just to meet the demands of Gen Z students, but because it benefits the institution as a whole. Thinking about Dr. Taylor's work and his experiences, students perform better. They understand their role as lawyers. They understand the power of the law when we create cultures where that is the goal. So what are the opportunities? One, let's be open to change. recognizing that that's the way we've always done it probably won't be sufficient for these students. So let's talk a little bit about the characteristics of law school culture and where I think the most change can occur. So, and as I was researching and writing about law school culture, 3 characteristics sort of came to mind for me when I thought about law schools. Law schools are competitive, they are exclusive, and they are steeped in inequity. So the architect of the current model of legal education is Christopher Columbus Langdale. He's given that credit. He is credited with the current curriculum, which relies on Socratic dialogue, use of case method to teach the law using cases, a uniform curriculum, what Dean Lewis talked about earlier, embedding the curve. Because for him, competition is what students need to improve performance. But my research about Gen Z tells us emphatically, Gen Zers are not motivated by competition. They are motivated by making a difference for others. They are inclined to work harder and more towards a goal when they can see how that goal is connected to a cause they believe in. So you want students invested in learning about Blackacre? Well, let's figure out how we can teach Blackacre in a way that connects. I'm a first-generation law student. My family rented. I had no concept for what you were talking about with deeds, right? But if a professor had figured a way to connect this to how I experienced the law or how I experienced life, perhaps it would have stuck with me and I would be able to tell you about anything dealing with property law, which I cannot. Second, law schools are exclusive, not just in who gets into law school, but who's selected for opportunities. Only a few students can receive A's. Only the top students earn a spot on law review and moot court. If you're a first gen student like myself, you grappled with this invisible curriculum. Legacy students seemed to know things I did not know, and I struggled under the crippling weight of stereotype threat that I did not belong as a first gen Black woman. And this really did have impact on how I experienced the law, how I performed in school, and whether I was willing to seek help, because I worried that it would somehow confirm these negative stereotypes about my identity. So law school is exclusive. And finally, it's steeped in inequity. And the inequities in law school run deep. So Dr. Taylor's work with LESI, if you look at the 2020, I think, LESI Diversity and Exclusion Report, it shows just how differently students of color, students from other identity groups or historically excluded groups respond or experience law school very differently. So what does it mean to do something for the culture? One, it's not just about, again, meeting Gen Z needs just because Gen Z, but also thinking about the sustainability of legal education. Gen Z students know that they could go out and work and record some reels on TikTok and make $17 million. They know that there are other options. There are other ways that they can make an impact with their voices. We want them to understand the power of the law. We must be willing to reimagine how we communicate, how we teach the law, how we create cultures around the law if we want to sustain the programs and sustain the value of law degrees. Charles Hamilton Houston, powerful architect, created a cadre, an army of students battling civil rights discrimination, and they did so because he created a culture where their interests were prioritized. So for the culture means carrying out a specific action for the benefit of a shared culture. It means doing something one might not normally do, but because the value of doing it is so high, you do it anyway. So even if personally you might not find benefit or value in implementing these changes, maybe we don't want to get rid of the curve because our grades were curved. Well, if it means changing things to impact this generation and to better prepare them for the law practice, then I challenge you to do it for the culture. So how do we be the change in our law schools? So how do we create one identity safe institutions where racism is excluded and we have replaced it with inclusion, equity, and representation? So one, let's get to the core. Dean Lewis mentioned Standard 303C, which the ABA recently proposed, which will require law schools to provide education on racism at the beginning of law school and at the end. training faculty, hiring a critical mass of faculty of color and from other historically excluded groups so that we show students that they can achieve this outcome, that they are welcomed in our space. On identity safe classrooms, I've written an article about amplification, and I know my time is up, so I'm wrapping up. One of the things I talked about is how to create a identity safe classroom by creating opportunities for mirrors and windows. In a mirror, we see our own identity reflected. In a window, we see into someone else's experience. Far too often, students like myself come into a classroom and we're only looking at a window. We're only seeing someone else's experience that has nothing to do with our reality. So when you're developing your final exam, your writing prompts, your hypos, look for opportunities to create a mirror where your student sees their own experiences reflected. Maybe your business owner is intentionally named as a Black woman or a Latina woman or some other way that you can create that opportunity, and several others here that I won't read. So what comes next, in the words of King George, we need to listen to our students. I love that Dean Jefferson mentioned listening. Listen to your students, talk amongst yourselves, figuring out ways to do it, how to create change, how to reimagine legal education, and how to do it for the culture. Thank you.
Great, thank you so much to all the panelists, highlighting a lot of issues that, oh, I'm sorry. Oh, okay. I didn't know if you had anything else to say. Okay, so thank you again for the presentations. And now I'm going to open it up to questions from our viewers. So if you have any questions, there should be a chat next to the live feature on the VLS website, and you can pop them in there. But there are a few questions to start, and I'm going to start with Dr. Taylor. Dr. Taylor, do you have an example of case law that you were taught versus how you would teach it now that you've evolved your teaching style?
Yeah, I mean, I think the property example that Professor Atkins used is a good one. There's a case in property, I think it's McIntosh, somebody v. McIntosh, or McIntosh v. somebody. It's a classic property case. And I remember we were talking about it, and it's about basically how, folks stole land from the Native Americans. That's not the issue in the case, though. The issue in the case is something procedural about judicial review. But the context was land being seized from the Native Americans through treaties that were not respected, and through violence, of course, that we knew what happened. And so I'm reading the case. I can remember 25 years ago as a first-year student, I'm reading this case, and I know generally what I'm supposed to get out of it has nothing to do with the context, but the context was distracting. Because again, I'm thinking about how this issue even came about in the first place, but I'm supposed to focus my thinking on this concept of judicial review, which came out of the case. So if I was teaching that, and I'm not a property professor and I won't ever be, but if I was teaching that, we would talk about the context, because we should address how property law came about in this country. It came about through violence, force, stealing, a whole bunch of stuff that we've codified and legitimized. But we should talk about that. So that's certainly one example. I mean, there are a million others. I graduated from Howard Law School, and we definitely did delve deeply into the context of stuff, particularly in con law courses and things like that. But that's definitely one example where literally the context was distracting me from what I was supposed to take from that case.
Thank you. We have another question, and this one is for Professor Roberts. So how do you teach your student clinicians to work through their implicit biases as they work with clients, mostly focusing on what you have seen has worked and versus what hasn't worked?
We have case rounds, and so we have an opportunity to discuss the case in general, and then we have an opportunity to discuss their interactions with their clients. And that's an opportunity for them to discuss, what is working well and what's not working so well, right? And part of it, I start with my own biases. I have my own point of view about this client, right? And so I'm suspending that. But let's look at, what are the concerns that you have? What are the client's goals that person has? And so we all go around and we really talk about, separating our own selves from what we think the client should do, but really realistically, what is the client trying to accomplish? How can we make that happen within the bounds of the law? And what story can we craft that will be that the court will hear, right? We'll be able to act to really support what our clients' goals are. And so we do case rounds at least every other week. I do have meetings with them every week. And so we have an opportunity to talk about those type of cases, and also about their frustrations, right? What are victories and their frustrations, right? And then try to brainstorm them, and hopefully to have them reflect on what they've done well and what things they can improve on. And also to know that the clients are not the same. Everyone is different, and they have to be flexible in learning how to pivot and be flexible with their clients. So I think a lot of it is reflection and discussion about biases, and calling out biases, quite frankly, calling it out, and in a respectful way, but in having the students to realize that and how they can address their biases going forward with a particular client.
Great, thank you. Okay, so here's another question. This one's for Professor Atkins. Is there one thing that law schools can do in their curriculum that could have significant ripple effects? What comes to mind?
So I think the one thing is sort of reimagine the 1L curriculum. Right now, we get in and we tell students, you've got to learn contracts, property, right? And we don't teach it in the social context. This is what Dr. Taylor was saying. You can't teach any case without the social context that it was created in, right? When we're talking about these issues. So I think we need to reimagine that 1L curriculum, and from the beginning, embed advocacy opportunities. So if we're working through property law, you need to absolutely be talking about Native peoples, Indigenous peoples, those rights, connected to a clinical experience, connected to something that makes it real. So when I teach my legal writing class, I used to practice public housing law, so I represented folks in their evictions. And so when I created a problem where it was an eviction based on record, a person had drugs, they were automatically evicted, and I gave her facts, I gave her meaning and context. She was a single mother. A student who hadn't performed well came and said, I was raised in a similar background. He dug into that problem and did so much better. He was a better writer because he felt like he understood this person. So I think the 1L curriculum, any ways we can embed advocacy right away into that curriculum, I think that will have exponential impact on students' connection to what they want to do, which will probably also improve performance, that sense of belonging, because I see myself reflected. I see this opportunity to give back to a community that I feel passionate about.
As a follow-up to that, and I will open this up to all the panelists, now that the ABA sort of passed standard 303C, how do you think that will impact the law school curriculum? And in what ways do you think that it could have, does it do well, and ways that it could have been written better?
I'm always suspicious of things that say, do it at the beginning and then at the end, because what happens in the middle, right? But when this was originally contemplated, someone shared a thought with me that I thought was very spot on, and they said there should be a requirement that faculty get this training first and foremost, because frankly, if the faculty member is sensitive to all these kinds of things, they can impart all of that on their students. So we're kind of focusing on, I think now, after again, this person shared it with me, I think we're focusing principally on the wrong population. It needs to be the faculty, the administrators, the people who set the tone, who set the curriculum, who teach the classes, who provide the co-curricular opportunities. Those are the folks who need this training, and then they can, extol all of these things and these values onto their students.
I agree with Dr. Taylor. I'd also add that when you read the interpretations, when they give you the rule at the bottom, you had the interpretation, and there were several ways schools could achieve it. And it was, you could do it through orientation, you can do it through an existing course. It seems as though you could fulfill it by saying, well, someone mentioned this in a class and we can check that off. And that's not sufficient. Not only do faculty need to be trained, because often it's more harmful to introduce a topic from someone who doesn't understand it, and just presents a case and doesn't give that context. That's harmful for the student. So I think that improvements, one, create a better structure for faculty to be trained, and then two, it can't just be check the box because I mentioned race on one day in one class. How could we be more consistent, more thorough? I'd like to see them revise some other standards too, but another conversation for another day.
I think there's some fear about autonomy, about professors being autonomous and developing their curriculum. I think that's a red herring, to be honest with you. I think they have more autonomy than they think, and I think they need to make it a priority. It's whether or not you want to make it a priority. That's the question, in my opinion. So, I totally agree with what Tiffany and Aaron has said. I'm curious of how it's going to be implemented, and is it going to be lip service or is it going to be the real deal? That the jury's out on that, so I don't know how it's going to roll out.
And one more comment. This is interesting because what I'd like to see is the enforcement piece of it. In the paper, one of the things I suggest is this should be connected to that annual review form we all have to fill out. If you put that on that annual review and you connect it to someone's raise, I think we might begin to see that forward movement, because otherwise it's going to be, I checked the box, I did this thing and I'm done. But if it's substantively, what have you done? List it, explain it, describe it. How have you comported with this standard? Put it at the top of the review form, not after you've talked about scholarship and all that. Put it at the top, prioritize it in that way. We might begin to see some additional change.
How would you all reimagine the 1L curriculum?
Well, I think in some ways it doesn't necessarily have to be uniform across the board. There are a lot of different ways you can reimagine the curriculum. I think as a general proposition, the notion of what does democracy mean, what does justice mean, what does it mean to live in a society that's supposed to be guided by the rule of law, some of that foundational stuff that maybe some decades ago used to be taught in middle school and high school is not being taught anymore, and we're seeing it play out in larger societies. So, I think it's really a focus on values, and when you have brand new students, first year students, as Heather, I'm sure you remember, you're so open to everything. You take everything that people say is gospel. So let's talk about what it means to be guardians of the justice system. It's not just about representing clients. That's very important. I used to teach ethics, and your client is, you do everything you can, legal and ethical, to protect your client's interests, but it's also about protecting justice. We have a special responsibility per the preamble of the model rules of professional responsibility. We have an obligation to be private citizens with special obligations towards this notion of justice. So let's teach that first. Let's lay the foundation and embed it throughout the curriculum, but definitely early on.
Yeah, I agree. I think that we take for granted that students know these things. So I teach race law to 2L and 3L students. And I'm from DC, so I had a pretty good base of knowledge. And so when I came here and teaching it in the South, I I thought students knew more. And I was very surprised by what they didn't know. So I don't think we should take for granted that they're being taught, the same thing. They have the same base of knowledge. I think we have to create sort of this foundational education about the real roots of our American legal system. Why do we have racial classifications? Why does this matter? Why did it matter? Why does it matter now? When did they begin? Because I think that really does touch into so many different areas of law. So I do agree that there should be some sort of foundational course, maybe taught, in conjunction with all these other courses that give that social context for property and contracts and everything else.
I think also maybe an opportunity for a practical experience, because I think it's nothing better than, you talk about civil procedure, a certain concept, and you see it in action. It makes connections there, right? So I think that some law schools are actually trying to have a practical stint or practical experience with first years. And I think that's also can give them not only the law piece and how it works, but also context about me dealing with individuals who are different from me. So I think that is too, that needs to happen too.
Sort of on the flip side, what advice can you give to students who want to challenge a way that a professor taught a case, or a supervisor who, said something that may have invoked some sort of bias? What advice would you give to a student who is in the classroom or in a clinic, sort of like on the other side?
Well, you start.
So I think it all depends on the professor, right? I mean, I think I know my students and I've kind of built a rapport with them. So I'd hope they'd feel comfortable enough to come to me and say, hey, I read something in the case. You talked about it differently. Can we meet? Can I come to office hours? I want to understand it a little bit more. But I do think it's within the student's right to say that. I think they should, and I think Dr. Taylor mentioned that it was on his evaluations. It'd be great if we could find this out beforehand, because that way I can correct it. So maybe if Dr. Taylor had known this student had that concern, maybe the next class could have been, last class, I didn't say something when I should have, right? There's opportunity to correct in the classroom. And that's, I think, when it's most instructive. So this will vary from person to person. I'd rather know it. I'd rather my student come and say, but I think, of course, you can't guarantee what the outcome will be, what the person's response will be. But I think it's all in how you propose it, right? And if you come and say, I read this, I think I understand, but this seems different. Can we talk? And that way you might have shared or enlightened the professor. They may have never thought about it that way. And I think it's a learning opportunity for both of you. The same thing on a clinical. I think you need to talk to your clinical super, like if you're on a site somewhere, maybe talk to a faculty member about how best to approach that. But I do think that it's appropriate always to challenge and to ask questions about how and what you're being taught.
Yeah, I mean, if you're in law school, you're trained to be a professional. And when one of the, notions of a professional is you approach people and have conversations as opposed to necessarily holding things in until things can get hostile. Your school should also have resources. So there might be an administrator that you can go to and just talk generally about the problem, and they can give you some insights about how to best approach the professor, how to best frame the discussion. And then if there's something that's actionable, then there's a process for that too. And, nobody should ever tell you not to pursue it. There might be situations where it might not be advisable, and that's a judgment call that you should make. But if things are actionable, there's a process for that. But short of that, there should be an adult conversation about your feelings, and it may not end in agreement, but at least you're able to express that and then adjust. In the end, the professors can design their courses largely in the way they want to. So it's not an arm's length kind of negotiation. It's more you bringing it up and hoping that some improvements happen.
I think also that it could be very difficult for students to have that conversation, because on the one hand, you control my grade. So, I want you to like me, But on the other hand, I want to have my say in what I need to say. I think I do try to, I'm not infallible, I mess up all the time. And so, I don't have a problem with people coming to me and say, hey, but it's all about how you do it. I do agree with that. All how you do it as an adult, as a professional, because I'm teaching you that that's how you will handle things regardless of in the classroom and things like that. But I think the creation of safe environments, safe places to come and talk, even if it's anonymous, if I need to say something, but I don't feel comfortable in putting my name, but at least you can send it to me and I can address it, right? So you don't have to tell me who it is. So I thought about that as well as having an opportunity to, for students who don't want to be anonymous, to send me stuff, send me like a comment or something they want to discuss in class.
All right, here's a question from the chat. Do you have suggestions for white student allies who are passionate about helping to create a safe space beyond continuing to hold our administration accountable?
Well, there's often power that comes in number, power that comes in overrepresentation, and most law schools have an overrepresentation of white students. And so you can use that to the advantage of people and causes who may be marginalized. And in the exact way you do it is first educating yourself on the issue. And it's not just book knowledge, but it's also talking to the people for whom you want to be allies for, and actually seeing what they think, seeing how they're feeling, and then demonstrate some empathy in trying to understand that. And then with, I believe, permission, that's when you go and do affirmative things as an ally. In my opinion, the people who are being victimized by something are the people who should have the power to say, yes, do this, no, don't do that, say it this way. I don't think it should be driven by the ally. It should be driven by the person you're allied with. And so it really requires, in some ways, like I said, demonstration of empathy, but then also knowing that you don't control it. You don't control. In other words, you're taking marching orders from the people that you are allied with. I think that's very important.
I agree with that last part. It is really important to respect and to support people the way they want to be supported. So just swooping in and saying, okay, I'm going to fix, well, that doesn't really give them that agency, ability to advocate for themselves. And I think also, often the students who hear conversations, we don't, right? So if you hear conversations that are happening, that are attacking students, that are otherwise creating some unsafe spaces for students that we may not hear, I think that's a space, right, where you can, in your own circle, begin to do that kind of behind the scenes advocacy. That's not okay. Don't be silent when these things are said. To the extent that you can exert your own influence in those spheres, I think that's really important. So it's not just the up on stage in front of everyone, here's how I'm an ally, or here's how I'm an accomplice, but here's what I'm doing behind the scenes to create space for these students to feel as though they can belong, where there's a bit of safety.
Well, it looks like there are no more questions and we have just a couple of more minutes. So I just wanted to see if any of the panelists had any last words they wanted to impart before we end the panel.
I'll just say, generally, I think the law degree is the most powerful degree a person can get. And with that comes responsibilities for us as legal educators and also for law students to know that it's not just about going out and getting a job. I know the student loans are big, but there's options for that. And if you need help with that, let me know. I can talk you through student loan repayment. But it's also about this larger notion of preserving our democracy and preserving all the things that we say we hold dear, because frankly, we're seeing an unraveling of a whole lot. And I don't know how far and how deep it will unravel, but we're absolutely seeing an unraveling of a whole lot of things that many of us took for granted. And if lawyers aren't in the middle of preserving this stuff, I don't think there's much hope for things to remain the way that we've become accustomed.
I'd add students continue applying pressure. When you're not receiving, your law school isn't living up to what they say they're going to do. If you're not being equipped or trained to do that kind of advocacy work Dr. Taylor talked about, apply the pressure, right? And of course, we're going to talk, respectfully and what have you, but don't buy into the respectability politics either, but another conversation. But keep applying that pressure to make sure you are heard and that your voice is not ignored, that you're getting what you need out of your education.
I guess also don't ignore what's happening around you outside of law school, because that can just be as informative as what's happening in law school, right? And that as law students or as prospective lawyers, you do have a power and a privilege that others do not, and that there are things that you can do even not as a lawyer in law school. So just keep in mind of other things and other advocacy things that you can do, not only in law school, but also outside in your communities.
Great, thank you all. And thanks again for joining us for the first Embedded Racism in the Law panel series of the year. And I am just so excited that this was the first panel that we had this year. And I look forward to working with you all in the future. And we sent around information to our student body about each of you papers that you've written. And so I hope that people can learn more about you and your work if they have any more questions after the panel. Thank you all for joining us and have a good night. And hope to see you at the Race in the Law Symposium on Saturday.
Thank you.
Thank you so much.
Thanks, Heather.